What if your state no longer required a permit to carry a firearm because the highest court in the land just made it unnecessary? In a stunning 9-0 decision, the U.S. Supreme Court has just dropped a legal earthquake, effectively pulling the rug out from under permit-based gun laws across the country. Even more shocking, the Department of Justice is backing it, and so are multiple states. This isn't just a legal decision, this is a signal that the era of forced permits may be ending. And what comes next could change everything. Welcome to Firearms Law Advisor, where your rights, your safety, and the truth always come first. Let's break this down. Chapter 1. The Permit Wall Falls. For over a century, states have used permits to control firearm carry. Whether it was concealed or open, you needed permission. But the court just said that the entire model may be unconstitutional. What the decision clarified? The right to carry doesn't begin after approval. It begins with the Constitution. Permits create delays, taxes, and subjective approval systems, all of which violate the Second Amendment's core protection. A shall not be infringed right can't be locked behind a bureaucrat's discretion. This chapter of American gun law is being rewritten, and it starts with permits becoming relics of the past. Chapter 2. The DOJ's shocking support. Yes, you read that right. Even the Department of Justice didn't oppose the ruling. This isn't normal. Historically, the DOJ fights any case that expands Second Amendment protections. But here's what changed. The DOJ quietly declined to challenge the court's direction, signaling acceptance. Internal memos, cited in court filings, revealed that DOJ attorneys believed permit systems were legally fragile post-Bruin. 15 states joined amicus briefs, saying they support the shift to permitless carry. Let that sink in. The very agency that used to enforce permit rules is now stepping aside. Chapter 3. What this means for constitutional carry. This ruling didn't invent permitless carry, but it legally validated it nationwide. Until now, states offering constitutional carry were often on shaky legal ground, facing lawsuits, federal interference, or activist judges. But now, constitutional carry is no longer a red state experiment. It's a federally protected right. Blue states that restrict carry without cause are now legally vulnerable. Future laws that attempt to reintroduce permitting will likely be struck down quickly. This is the federal green light constitutional carry needed, and it's already triggering action. Chapter 4. California, New York, and Illinois on edge. The states with the most aggressive gun control laws are already scrambling. Here's why this ruling has them panicking. California's may-issue regime is DOA. New York's strict concealed carry permit system, which already faced backlash after Bruin, now has no legal leg to stand on. Illinois, still recovering from litigation over magazine bans, now faces a flood of lawsuits over its permit schemes. Fallout already beginning. Lawsuits filed within 24 hours of the ruling in California, challenging both carry and training requirements. Sheriffs in rural counties are refusing to enforce permit checks. Gun rights organizations launching campaigns to overturn state-level restrictions, using this ruling as a weapon. Chapter 5. The permit industry collapses. There's a billion-dollar industry behind permits, from application fees to mandatory training courses and ID renewals. But that empire just took a hit. What's collapsing? Revenue from permit applications is drying up across red and purple states. CCW instructors and certification businesses are seeing cancellations. State-level databases for firearm carriers are losing legal justification. This was never about just safety. It was also about money and control, and both are evaporating. The system built on permission is being replaced with a system based on rights. Chapter 6. States moving fast. Some states aren't just celebrating. They're moving strategically and fast to implement this Supreme Court decision in a way that permanently changes their laws. This isn't just symbolic. It's practical, tactical, and very real. Here's how states are reacting. Florida's governor ordered the elimination of concealed carry permit requirements by year's end, calling the court's decision a course correction for the Constitution. Montana and Texas passed emergency legislation to expand where constitutional carry is recognized, including in places previously deemed off-limits. Tennessee's Attorney General issued statewide guidance declaring all local permit requirements void under the new interpretation of the Second Amendment. South Carolina and Alabama are now considering state constitutional amendments to reflect the federal ruling locking in protections beyond the court's current composition. What's important to understand is this: these states aren't just reacting, they're preparing for legal resilience. They're writing laws that will be harder to strike down in future battles. And perhaps most importantly, they're proving that freedom spreads fast when courts open the gate. Chapter 7. Police, sheriffs, and enforcement chaos. One of the biggest ripple effects no one talks about: enforcement confusion. Police departments and sheriff's offices across the country are now stuck in legal limbo. What law enforcement is dealing with: some departments still require permits even though the law just changed, causing tension with state AGs and sheriffs. Local prosecutors are dropping charges related to permit violations, saying they won't risk civil lawsuits. Constitutional sheriffs in counties across Arizona, Georgia, and Idaho have publicly declared, "We will not enforce permit checks." This is a rare moment where federal law, state policy, and local enforcement are clashing. But one thing is clear: carry permit enforcement is collapsing fast, and citizens are caught in the middle. Chapter 8. The gun control lobby's response. Gun control groups didn't take this lightly. Within hours of the ruling, they launched PR campaigns, emergency fundraisers, and even drafted new legislative proposals. Key reactions from anti-gun organizations. Everytown for Gun Safety called the ruling a national disaster. Gifford's PAC pledged $20 million to fight the decision at the state level. Brady United is working with governors in blue states to introduce new training requirements as a workaround to permitting. California and New York introduced proposals to classify more carry zones as sensitive, making most public areas off-limits. Here's the catch: none of these measures can survive long-term if they violate the court's ruling. But expect a legal chess game where gun control advocates try to keep their restrictions alive using loopholes, definitions, and public safety arguments. Chapter 9. The historical shift. This moment is bigger than any single law or decision. It's a massive historical shift in the way the Constitution is interpreted regarding gun rights. This ruling doesn't exist in a vacuum. It's the latest piece in a long chain of constitutional victories that are now converging. The broader constitutional impact. This ruling builds on the foundation laid by Heller, 2008, which affirmed an individual's right to bear arms. It aligns with McDonald, 2010, who applied that right to the states through the 14th Amendment. It continues the wave of Bruin 2022, which demanded a text, history, and tradition test for all 2A cases. And now it applies that test directly to carry permits, setting an irreversible precedent that modern policy preferences cannot override historical rights. What we're witnessing is the end of a decades-long legal strategy by anti-gun groups, one where they hope to outlast the court. But with this decision, the court isn't just catching up, it's leading. We've entered a new constitutional era, one where gun rights aren't a gray area but a guaranteed freedom backed by the nation's highest court. Chapter 10. What's next? With this ruling, America has entered a new era, but it's not the end of the road. It's just the beginning. Here's what to expect next: massive lawsuits against permit-based systems in the remaining blue states, expansion of carry rights into zones that were previously off-limits, parks, courthouses, public transit, federal lawsuits against states that retaliate with new soft bans, Supreme Court follow-ups to clarify sensitive places, magazine bans, and accessory regulations. This is the moment the map begins to shift permanently, and Survival Firearms will be here to cover every single change, every single ruling, in real time. Let's be honest, nobody thought this would happen this fast. A permitless future. DOJ backing it. States rewriting laws. Gun control groups are scrambling. But now it's your turn. If you believe this is a step in the right direction, share this video with your friends, your family, and your fellow carriers. Hit that subscribe button right now. Firearms Law Advisor is bringing you real-time updates from the media that won't touch. Fact-based, no fluff, and always for the 2A community. Drop a comment. What do you think happens next? Will your state follow the Supreme Court's direction or fight back? We're entering a new chapter in American gun rights. Stay smart, stay informed, stay free. We'll see you in the next one.